and welcome to this microeconomics course. Today we're going to be discussing economic competition and competition policy. Competition policy by governments may aim to encourage business startups, encourage entry into markets by removing barriers to entry, take actions against anti-competitive practices, prevent firms from abusing monopoly power. Competition policy can fine firms, force firms to remove barriers of entry, make firms sell off their assets to break up dominant firms, introduce price controls and stop collusion, as well as block mergers and takeovers. The Office of Fair Trade, or the OFT, led by the Director General of Fair Trading, the DGFT, is an independent body funded by government for making sure that markets work in the interests of consumers, for example, preventing and stopping firms from abusing their market positions. It can impose sanctions or refer to the Competition Commission for investigation. The Office of Fair Trading can fine firms up to 10% of their turnover if they're found guilty. The Competition Commission investigates potential monopoly situations. The firm or group of firms is defined as having a dominant market position if it has a market share of 40%. It has a monopoly if it has a market share of 25%. These definitions refer to local as well as national markets. Privatised monopolies such as British Telecom are regulated by regulatory bodies such as Ofcom. The European Commission investigates and punishes firms guilty of breaking EU competition law. Firms can appeal to the European Court of Justice. EU restrictive practices policy. Article 81 covers agreements between firms and practices that prevent, restrict or distort competition. It aims to restrict collusive behaviour. Practices that are considered anti-competitive include collusion to fix the price, limit production, markets or investment and share out the market. European monopoly power. Article 82 relates to the abuse of market power and has been extended to cover mergers. EU mergers. In 1990, legislation covers mergers where the combined worldwide sales exceed 5 billion euros, where EU sales are of at least two of the companies exceed euro 250 million, and where at least one of the companies conducts no more than 2/3 of its EU-wide business in a single member state. UK competition laws. 1948 Monopolies and Restrictive Practices Act. Monopolies are to be investigated on an individual basis. It is not to be assumed that they are always acting either for or against the public interest. The 1956 Restrictive Practices Act. Firms are obliged to register any restrictive practices agreements. These are assumed to be against the public interest unless those involved can justify them into the restrictive practices courts. The 1964 Resale Prices Act. Minimum resale prices are prohibited. The 1965 Monopolies and Mergers Act. Monopolies can now be investigated. And key to all of the above, the 1973 Fair Trade Act. This created the Office of the Director General of Fair Trading, who advised the Secretary of State. Monopolies can now be referred if they have 25% of the market. It used to be 33%. Nationalised industries can be investigated. Local and national monopolies can now be investigated. The 1980 Competition Act aims to deal with anti-competitive practices by firms, for example, predatory pricing, which involves selling products at a loss to drive out a competitor. Full line forcing, which involves making retailers buy the whole product range even if they only want one product. Exclusive supply, selling only to one outlet in an area. The 1998 Competition Act. This act prohibited anti-competitive agreements, cartels and concerted practices based on Article 85 of the EU Treaty. It prohibited abuse of dominant market position based on Article 80 of the EU Treaty. It established that a Director General of Fair Trading, the DGFT, would be appointed by the government. The DGFT is responsible for overseeing competition policy and consumer policy. He or she has the right, along with the Secretary of State for Trade and Industry, to refer a monopoly to the Competition Commission for investigation. Established the Competition Commission, formerly the Monopolies and Mergers Commission. The Competition Commission investigates potential monopoly situations. The 25 and 40% rules of the 1973 Fair Trading Act are reinforced, with fines of up to 10% of their turnover available if found guilty by the Secretary of State. The 2002 Enterprise Act. The Competition Commission must determine whether the merger will impact adversely on competition. In other words, if it prevents, restricts or distorts competition, the merger is then likely to be blocked. UK competition policy is generally pragmatic. It appreciates the potential gains as well as the costs of monopoly power and investigates each case on its own merits. Cartels. Each Enterprise Act identifies certain situations which would result in the prosecution of unlawful behaviour of the actions of at least two firms. Directly or indirectly, fix a price for a supply in the UK for a product or service by those firms. Limit or prevent supply in the UK of a product or service by by the firms, limit or prevent production in the UK of a product or service by the firms, divide between firms the supply in the UK of a product or service to a customer or customers, fix the terms in which a bid in such a way prevents the normal operation of the bidding process. Punishment can include up to 5 years and also a fine. Other anti-competitive practices include resale price maintenance. This occurs when a firm fixes the price or the minimum price at which the shops sell their goods, refusing to supply. A firm may refuse to sell some companies to some companies. If the business will not sell at a price it wants to, it will not take competitors' products off its shelves. Predatory pricing occurs when a firm sells at a loss to drive out its competitors. Once they are removed, prices will increase again. Tie-ins. A business may only agree to sell one of its products if others are bought along with the same time. Types of business. There are numerous types of business formed inside of the UK. Firstly, a sole trader. An individual runs his or her own business. The owner is personally liable for any debts and has unlimited liability. Partnerships. Individuals work together and share joint responsibility for any decisions with unlimited liability. A company. A company has a separate legal existence from its owners. The owners have limited liability. Companies are owned by shareholders. Private companies have the letters LTD after their name, limited. Shares cannot be advertised. Public limited companies have PLC after their name. Shares can be advertised and traded on the stock exchange. Public corporations or nationalised industries are in the public sector. Shares. Shareholders and part owners of a company. Usually they have one vote per share. More shares equate to more votes. Shareholders vote on the amount of dividends or rewards to be paid out and how much should be retained in the business. Shareholders may also gain by selling their shares at a higher price than they paid for them originally, although the price can also fall. These are baseline concepts. The actual procedure for these carries considerably over time will evolve. Before taking advantage of any opportunity based on these, you should seek independent advice from an independent specialist. It is very complex as a situation in an area, and one minor adjustment to any fact in any way can impact on whether something would be suitable for you. Multinationals or transnationals. These are firms which have production facilities in more than one country, such as Shell or BP. Why become a multinational? To exploit resources in different countries, such as cheap labour, to reduce risk of stoppages and reduce union power. If there is a strike in one country, production can continue elsewhere. To enter markets. Some governments, such as China, are reluctant to let foreign firms in unless they are based in the country. To be closer to a market, reducing distribution costs. To benefit from fewer regulations on health and safety, for example. Benefits to countries of having multinationals locate there. Foreign direct investment by multinationals may bring jobs, creating more income and generating tax revenue for the government through the multiplier effect. Bring knowledge, bring methods that lead to higher productivity and lower unit costs. Invest capital, boosting demand. Pay corporation tax, provide more choice for consumers. Stimulate economic growth and improve the balance of payments on a current account by boosting exports. Why might governments be suspicious of multinationals? They may not use local employees and only do so for unskilled jobs, therefore not benefiting the skill base of an area or region. They may not reinvest profits. They may damage the environment, as we've discussed in an earlier section, and they may exert power over the government, considerable power in some cases. Growth of firms. Internal organic growth and external growth. Internal or organic growth occurs when firms sell more of their products. External growth occurs when firms join another business. This may be through a takeover, which occurs when a business takes control of another. This is called an acquisition or a merger, which occurs when a firm joins together with another one to become a new business. External growth tends to be quicker than internal growth. It can lead to rapid changes in the size of businesses. It can be good in terms, for example, of shared resources, market power, purchasing power, or the ability to produce on a large scale, such as internal economies of scale. However, it can bring problems with managing a much bigger business. For example, problems of coordination, communication, motivation and control leading to higher unit costs. In short, diseconomies of scale. Why takeover or merge with another business? One of the main reasons is to access a new market and maybe a way of communicating and overcoming protection methods. Fast growth, share resources and expertise. This can create synergy, the 2 + 2 = 5 effect, where every input, when aggregated, causes an output greater than the sum of its parts. Share strengths in different areas, for example, different regions of the world. Cut costs. For example, it will not necessarily need 2 research and development teams or 2 marketing directors and so can make redundancies. Reasons for growth: safer from takeover, economies of scale, more market power, status, personal motives, for example desire of managers for more control. Types of growth: horizontal, with one firm or another at the same stage of the same production, this can lead to economies of scale. And vertical, where one firm joins another at a different stage on the same production process. Forward vertical, firms buy up one firm nearer to the customer, for example a distributor. Backward vertical, a firm buys a supplier and can guarantee supplies or access to the market. Conglomerate, a firm buys another firm in a different industry, for example a cigarette buys up a chocolate company. This can be used to spread investment and business risk. Share prices are determined by supply and demand. An increase in demand for shares should lead to higher prices. It may be because investors expect the company to perform well in the future, increasing share price and or the dividends paid. Confidence in the future performance of the business is therefore a major determinant of demand. Buyers may also be speculating about the price increasing in the future. Franchising. A franchise occurs when an individual or firm buys the right to another firm's name. It sells its product and uses its systems. A franchisor sells the right to the franchisee. For example, McDonald's franchises some of its outlets. Benefits of the franchising to the franchisor are that it can grow fast because the franchisee provides the investment. The franchisee should be quite motivated because they can provide rewards. They can share overheads such as marketing between the franchisees. Benefits of buying a franchise are that it can buy an established business with a proven track record. It can access and experience the systems of the franchisee and can learn from other franchisees. It can share costs such as marketing between all franchisees and the part of a bigger organisation, therefore benefiting from a national or international perspective.